So this is the revision sheet. Now, I've put this up on Sector, and it includes the answers for the questions, right? Some model answers. Some of you might recognise these answers. I did cut and paste a few of them for you. But we get to this last question. Okay. At the moment, the right to the presumption of innocence means that a jury does not learn about a defendant's criminal record before they make the verdict. However, when it comes to sentencing, the judge does know about a person's criminal history prior to sentencing. Do you think this process is fair? And explain your answer. Would you recommend changes to this or not? And again, explain your answer. So let's have a think about how we might answer these two questions. Okay. So you might say, first of all, I might identify, I think it's very fair that the judge knows a person's criminal history and so they can take that into account. So you might start with it. So an element of the process that is fair is the judge being able to see a person criminal history before sentencing them. Now, that's not enough because I haven't explained why. So I have to justify my statement. So this means can assess or not they have made an effort to change their behaviour after previous criminal conduct. So what I'm saying there is if a person's been convicted of a crime before, whether or not they choose to change their behaviour might be something that's really important to the judge. Okay, so there we go. Now, here comes a more important element, is the right to presumption of innocence means that the jury doesn't get to see a person's criminal history. So you've got to decide whether you're fair or not. I am going to argue that it is fair, okay, because I think that it means that the case has to be made against a person without relying on their previous guilt, so that we can be really certain that a person is guilty. So I'm going to put that in here. So I also agree, and because I've asked your opinion, I think it's okay to write in first person that it is fair that a criminal history is kept from a jury before they make their decision. Now, I'm trying to use as much legal language as I can. So rather than just use jury, I've also made it clear that I understand that a jury's role is to make a verdict. So that shows me that I know a few extra things as well. Fair person's criminal history. This means that a jury cannot be influenced by a person's previous criminal history just by the facts of a case. Okay. Now, there's another thing that we could talk to here, right? We could put some more emphasis on the right to the presumption of innocence and the fact that it makes it more important that the prosecution uses the facts to make their case. So I think both of those things are pretty important. Okay, so this supports by making sure the prosecution, so another good legal term, prosecution's the side bringing the case, like the police prosecutor or the Department of Public Prosecutions. The prosecution has to make their case, the evidence at hand. Okay, now, would you recommend changes? Now, there's two things that are really important in legal studies, right? Talking about the legislation, which we haven't talked about here so much, but talking about cases. So there is a case that's very, very interesting here, and we've talked about, and that's the Daniel Morcombe case. Okay. So there's a question that's raised as to whether the facts are really, really similar, whether a judge maybe should allow that evidence to be shown to the court. So let's talk about how I would change it. In one specific set of circumstances, I am of the opinion that there should be changes made. Okay, so we haven't done the best word of circumstances there. There we go, we fixed that up. In the case of Daniel Malkin, the accused had previously been involved in a crime with extremely similar facts. Okay, so we've talked about a case and we said there was this case that happened. Now, I can't remember the name of the person who was accused. That doesn't worry, I can just refer to them as the person accused. You don't have to have all the details in there. So in this case, I'll say, okay, so it would have been useful for the jury to understand that this was potential pattern of behaviour. If someone's done something exactly the same before, perhaps they're more likely to do it again. So on this basis, I would suggest that if a judge sees that a person has been convicted of a crime with similar facts to the current court case, they can choose to make this known to the jury. Now, I've made a pretty specific recommendation there. Okay, I said that it's the judge that takes control of this. They may choose to let the court case know. So I have recommended a change. I've recommended on the basis that people might have a pattern of behaviour. Okay, this allows a jury to take into account potential patterns of criminal behaviour. Okay, and there we've answered both questions, a paragraph each, and it's taken not too long, even if you didn't type quite as much as me. The important thing is, as well as making statements, we've justified it there, we've referred to a court case, and we've linked them to the important parts of the right to presumption of innocence and recommendations.